Elizabeth, can I ask a question of April as a backup question for the training agreement?
Absolutely.
One of the things that I've noticed, April, is that everybody and their brother is creating LLCs for their a way to put their businesses together when their kids are out riding, and they're creating these LLCs. And one of the questions I have is when I do the training agreements for them to come to the farm, our farm to board, they're signing it as the LLC, but it's their minor children who are doing the riding. When they're signing as the LLC, am I leaving myself open as a business owner because I don't have the parent, them signing as the parent of the child for the training agreement because they're signing as a business?
Absolutely. That's a great question.
That's a really good question, Pam.
Well, when you get the LLC signing, obviously, well, maybe not obviously, but people are setting up the LLCs to limit their personal liability in the event that something happens with the horse. Typically, these LLCs are underfunded, undercapitalized, underinsured, you name it. There are not a lot of assets backing up these LLCs. So to the extent the LLC signs a training agreement and that training agreement contains a release and an indemnification clause, you may be able to enforce that indemnification clause against the LLC to the extent it has funding. But when you run out, when you deplete those assets there, you'll have to jump through the extra legal hoop of piercing the corporate veil to go after the individuals that created the LLC personally and individually. So that is an extra hurdle. And if the parents of the child who created this LLC have respected all their corporate formalities, have maintained separate business accounts and separate records, which a lot of the people do not follow the corporate formalities. But if they have, you may not be able to pierce that corporate veil at all. What you might want to do, it may be okay to have the LLC sign the boarding and training agreement, but you may want to have the parents sign a separate release and indemnification agreement pertaining to the child. Now, what I have to caution you on, though, is in many, many states, Michigan, where I practice, is one of them, parents cannot release the claims of their children anyway. What you do get from having them sign a release and indemnification agreement is the indemnification agreement. So to the extent that the child brings a claim, the parents may have to reimburse your costs and attorney fees and liability to that child, which would deter claims. Now, not all the states have tested whether indemnification agreements executed by parents work to, compensate the business for injuries to their child. But it is certainly, you may want to consider the two separate agreements, the training and the liability release.
Okay.
Right.
Thank you.
And April, I don't know, and Pam, I don't know if either of you have had challenges with this, but I know that for when I had my horse business, my non-attorney clients didn't blink at indemnity clauses. However, if my clients that were attorneys had major issues with signing anything that had an indemnity clause, they would say things like that they can't legally sign that because their insurance policy doesn't allow them to indemnify anybody.
And
et cetera, et cetera.
Many times that's true. Many times that's true. Most, well, I can't say most, but many insurance policies do contain provisions that exclude any contractually assumed liability. So to the extent someone has signed one, they do not have coverage for it.
Okay. So is there anything, do you have any language that you can recommend that horse professionals use when that objection is brought up?
We have actually had people contact us where we have drafted their contract and someone has come to them and said, I'm not signing the indemnification clause. And basically it comes down to the personal decision of the facility owner. Are they going to stand by this agreement and lose the potential customer because, you know, if people say they're not going to sign, they will take their business elsewhere? Or are you going to make a modification to get that business in the door and rely on your insurance policy? That is essentially the decision that you're left with, is that you are waiving a legal right that you are entitled to if that party signs the indemnification agreement. And it comes down to a decision of, you know, your risk-benefit analysis. Is the business worth it is the business worth the risk?